Can you contest a codicil to a will? A codicil is the technical name for any document that amends, modifies, changes, or supplements an existing will. It operates in the same way as an amendment to a trust, despite going by a different name. A codicil can be something as simple as changing the executor of the estate, requesting particular property be distributed to different beneficiaries, adding a no contest clause, or adding the names of children born after the original will was made. Like the underlying will, interested parties can contest a codicil if specific legal requirements aren't met, or if there was undue influence, fraud, or incapacity involved when the codicil was created. If you have questions, take a look at our website, rmolawyers.com, to schedule a free consult. How do you challenge a codicil? To challenge the validity of a codicil, you'll need to file a codicil contest lawsuit in probate court in the county where the deceased lived. If the probate court determines that the codicil is invalid, the document's going to be disregarded and the preceding will or codicils will be considered the controlling documents. It's important to keep in mind that only interested parties, such as an heir or beneficiary, under a previous will can change a codicil. Such as an heir or beneficiary under a previous will can challenge a codicil. To initiate a codicil contest, you'll need to file a formal written petition with the probate court contesting the codicil and explaining why it should be thrown out. You'll need to be able to provide details that substantiate your claims, and you'll also need to secure supporting evidence and line up witnesses who can testify to that evidence at trial if needed. Once your petition's filed, the case is going to move into the investigation or discovery phase. During the discovery phase of the proceedings, each side seeks and secures evidence that supports their side of the case, including exchanging documents and information with each other. Codicil contests are often resolved through mediation, which is a formal settlement negotiation process that's usually conducted by a retired probate judge. If a settlement can't be reached, either through mediation or informal negotiations, then the case is going to go to the court. It's going to go to trial for determination. Does a codicil override a will? Yeah, basically, a codicil is going to override a will and any previous codicils to the extent the new codicil conflicts with the terms of those other documents. In other words, a codicil only changes those particular provisions contained in that codicil and generally will leave everything else alone. So whether a codicil will completely override a will or another codicil depends on the specific terms. For example, if the codicil revokes the will entirely, then the terms of the codicil will be the only provisions that the probate court's going to follow. This would normally be done through a new will that would revoke the old will rather than a codicil, but we've really seen everything. If the codicil only changes a few provisions of the will, such as who's named executor, then the court's going to follow every other term in that original will as supplemented by the codicil during the probate process. What makes a codicil invalid? As with a will, you can't contest a codicil just because you don't like what it says. Instead, you have to satisfy some specific grounds to challenge its validity. Here are some of the most common reasons why codicils are found invalid. The person making the codicil didn't have testamentary capacity. For a codicil to be effective, the person making it or executing it has to have testamentary capacity, which simply means they have to be of sound mind. While this requirement is one of the lowest mental capacity standards at law, people with severe dementia or mental illness may not have the necessary understanding, even to make a codicil. Undue influence, forgery, or fraud is another basis. So another common reason that a codicil may be invalid is undue influence. This occurs when a third party manipulates someone through extreme pressure, force, or threats to create the codicil or name them as a beneficiary or executor when they otherwise wouldn't have done so. Forged codicils also can be contested, as well as codicils that were created through fraudulent means, such as telling someone that the codicil was another, perhaps less important document when they were signing it. Another basis is that other legal requirements were not met. In addition to what we just discussed, the person creating a codicil has to adhere to certain legal formalities for the codicil to be valid. While the particular requirements are going to vary between the states according to state law, Everyone who makes a codicil generally is going to have to meet the following requirements. 1, the person creating the codicil has to be of age, generally 18, to make a will, according to each state's different laws. 2, the person creating the codicil has to have testamentary intent, which means that they must intend for the document to modify their will. Also, although again different in some states, the person creating a codicil typically must sign it in front of 2 or more witnesses, who also must sign the codicil. There is an exception to this requirement, however, for holographic wills and also holographic codicils, which simply means handwritten, where the document is written in the testator's hand. Have questions? Give us a call, shoot us an email anytime to schedule a consult. At RMO, we help people like you every day. Thanks for watching.